Resuming debate, the Honourable Member for Vancouver Centre.
Thank you very much, Madam Chair. I am really pleased to speak to this bill, C7 in its current form, mostly because I did not support the original bill, C14, 4 years ago. I didn't support that bill then because I felt that it did not reflect the actual intent of the Supreme Court of Canada in its ruling on Carter. I also felt that as a family physician who had practiced medicine for 20 years, that bill then did not actually act in the best interest of my patients. As a family physician, I walked with my patients, Madam Chair, through some really difficult times, through the joys of having a baby, of giving birth, of marriage, of all these things. But I also walked with them through the difficult and challenging and painful times when they struggled with excruciating and incurable diseases, when they struggled with knowing that they were going to die because of a terminal illness, and they were actually having to work with their families who may or may not have wanted them to go through this. And so I held their hand and I walked through them. And so for me, this bill had a very personal meaning, and that's why I'm pleased to speak to it now. Madam Speaker, I like this bill in its form in many ways. There are a couple of things I still think has not happened in it that I would like to see. But Madam Speaker, I want to say that the first thing about this bill that I am pleased with is that it removes the clause natural death to be reasonable, foreseeable. This was very difficult for physicians to understand what exactly that means. And if it meant only that people were actually going to die soon, what it did was it didn't reflect on what the Carter decision said in the Supreme Court ruling, because it didn't look at issues of incurable disease and an intractable pain and suffering. And so that was one of the reasons. And this now addresses that. I think in that it is distinguishing what you mean by natural death becoming reasonably foreseeable. In other words, I think it recognizes that if your natural death because of a disease and a terminal illness is going to be foreseeable in maybe a week or two, that you didn't need to go through that 10-day reflection that was asked of you earlier on. However, if it was a longer period of time, maybe 4 months or something, that actually you could continue to reflect on whether this is what you actually really need right now. I also like that what it did was it has placed back something called advance directives. Long before medical assistance in dying was considered, it was interesting to note that physicians used to have something called advance directive. This is at the heart of a doctor-patient relationship. You would sit down with your patient, you would go through all of the things that they faced, all of their concerns, especially if they were given a diagnosis that they had a serious and terminal illness. And they would say, look, you know, I really think if this happens, this is what I would like you to do. And that would be in writing between the doctor and the patient. But I was also present when those patients who, when they were dying actually, and in great pain, great suffering, and under the deep stress of all of that, would have their families debate their own desires that they had made earlier with their physician. So putting this back in means that we are respecting patients' desires. And, you know, if they're in mental capacity at the time of their dying, that they were respecting what they originally wanted, if they still wanted it, and not having other people rule on their decision. Inherent in everything I've dealt with my patients who were actually terminally ill or with intractable and incurable disease was that they wanted to die with dignity. Dying with dignity cannot be underscored, Madam Speaker. Dying with dignity means that people can choose how they die, where they die, the manner in which they live with the suffering of dying and the mental anguish of leaving their loved ones. This is a deeply personal thing that patients face. It's deeply personal. It's impacted by their religion. It's impacted by their own ethics. It's impacted by their family situation. And so this has to be done on a case-by-case basis. And I think an advance directive with the physician is always a really important thing. And that had been removed in the last bill. And so I'm glad to see it back. Because it took the decision away from the patient and gave it to the state at the end of the day. And now it's back with the patient. I want to applaud in this bill the inherent compassion that I see in it that I think is really important. That ability to say that if a patient is going to die, that deeply held desire of every single patient I know, regardless of whether they chose to have medical assistance in dying or not, was this ability to die with dignity. And so I think in this bill where we talk about the patient's ability to choose where they die is really important. Do they want to die at home in their beds? Do they want to die in a palliative care unit where they had become accustomed to spending their last days? Or did they want to die in a hospital? And I can tell you, most patients did not want to die in a hospital. They really wanted to choose to be surrounded by their loved ones. And I think that the government is giving $6 billion to provide home and palliative care resources to provinces, because that's the responsibility of provinces, who can facilitate this deeply held desire to die with dignity and can help the patient make that choice at a time when that ability to make that choice is often impacted by extreme pain and suffering and by the extreme mental anguish of knowing they have to leave their loved ones. So it simplifies this in a great way, and I think that is a compassionate thing. There are some areas I think can be improved, Madam Speaker, and I think one of them is singling out mental illness and disability as a sole diagnosis. Now, I agree with everyone who has spoken in this House today and the desire of a lot of people to recognize that that mentally ill people should not be deemed to be put away or should not be allowed to make a simple decision that they wanted to pass on, or the people who they were living with didn't want them around as a burden. And I think it's really important to look at this also from the disabled perspective. But I know that this minister has in fact spoken and taken a lot of time to speak with disabled communities, to speak with physicians, and this government is committed to dealing with mental health and illness, as actually my colleague from the Conservative Party actually said earlier on about this particular woman, a very moving story, who is contemplating suicide. So I think giving people the options when they are depressed and when they are disabled to know that there are other options for them, that there is a better life available for them, is inherent to dealing with this bill. And so I think that the idea that the minister is now going to look at this piece and consult broadly with the disabled community once again, as he's looking at the legislative parts of it, at the regulations and stuff, is really important that we're going to do this. But I think that because if we single out mental illness and disability as a sole diagnosis, we may be, in fact, contravening Section 15 of the Charter. That assumes that because you have a mental illness or because you are disabled, that you yourself do not have the right to make a decision with regard to your own life and your own pain and suffering, whether it be mental or not. So I think that the idea that this issue will go through and work with the provinces and with healthcare providers and disabled communities and stuff is really important. But I wanted to say that those safeguards will be worked out. I am going to be really clearly involved in hoping that we make sure that those safeguards are worked out and can be put into place to protect mentally ill people and people who are disabled. But I just want to quote, Madam Speaker, the late Justice Truchon in his decision when he said, "The vulnerability of a person requesting medical assistance in dying must be assessed exclusively on a case-by-case basis, according to the characteristics of the person and not based on a reference group of so-called vulnerable persons." The justice also added that the patient's ability to understand and consent ultimately should be the deciding factor with their physician and looking at all of the legal criteria. So I think those safeguards must be in place, but I do think that we should not assume that we can make decisions for people who, because of mental illness and disability, may wish to get medical assistance in dying. Because, Madam Speaker, intractable pain and suffering is not merely physical. It can also be mental. And with the help of good psychiatrists and good support systems, we will be able to put those safeguards in place. Madam Speaker, this bill has come a long way to rectifying many concerns that some medical practitioners would raise. And one of the ones I think is important is that it respects the right of a medical practitioner or a healthcare provider to actually use their own ethics and religion to decide whether they wished to perform medical assistance in dying.